The ideas expressed in City Club forums are those of the speakers and not of the City Club of Cleveland, IdeaStream Public Media, or their sponsors. Production and distribution of City Club forums on IdeaStream Public Media are made possible by PNC and the United Black Fund of Greater Cleveland, Incorporated.
Good afternoon, and welcome to the City Club of Cleveland, where we are devoted to conversations of consequence that help democracy thrive. It's Friday, January 23rd, and I'm Michael Dillon Brennan, Ambassador for the America 250 Ohio Commission. It is my honor to introduce the first forum in the City Club's America 250 Ohio series, in partnership with the America 250 Ohio Commission, and presented with Bank of America, Rock Family of Companies, and Cleveland Cliffs. Throughout 2026, the City Club will commemorate the 250th anniversary of the United States by exploring all the ways that Ohio has contributed to U.S. history for over 250 years. All year long and throughout the state, the America 250 Ohio Commission will celebrate and commemorate this semi-quincentennial anniversary Ohio style, with hundreds of events at the local level. In January, we recognize the unique contributions of Ohio's firsts and originals. It is fitting, then, that today we acknowledge and celebrate the contributions of America's first peoples, and welcome Matthew L.M. Fletcher, a leading tribal law expert, and the Harry Burns Hutchins Collegiate Professor of Law and Professor of American Culture at the University of Michigan. Since day one, and throughout the entirety of our country's formation, Native Americans served as defining threads and participants in U.S. politics. Article 1, Section 8, Clause 3 in the U.S. Constitution, known broadly as the Interstate Commerce Clause, and as it pertains to our discussion today, the Indian Commerce Clause, establishes a unique federal-tribal relationship, acknowledging tribal sovereignty and self-governance. Today, it serves as the backbone for federal Indian law, which spans hundreds of years and impacts both tribal and non-tribal communities. Today, we dive into how Native American nations helped shape the legal, cultural, and political fabric of the United States of America, and why these stories matter today. In addition to his position at the Michigan Law School, Fletcher teaches and writes in the area of federal Indian law, American Indian tribal law, Anishinaabe legal and political philosophy, and constitutional law, to name a few. He sits as the Chief Justice of the Grand Traverse Bay of Ottawa and Chippewa Indians, the Pokagon Band of Potawatomi Indians, and the Porch Band of Creek Indians, as well as an appellate judge for many other tribal nations. Fletcher co-authored the 6th, 7th, and 8th editions of Cases and Materials on Federal Indian Law, and 3 editions on American Indian Tribal Law, the only casebook for law students on tribal law in the nation. Moderating the conversation is City Club's own Director of Programming, Cynthia Connolly. For those who do not know, Cynthia is also a citizen of the Little Traverse Bay Band of Odawa Indians, which is located in northern Michigan. She also taught the Native American Studies course at Kent State University for over a decade and serves as the chair of the Lake Erie Native American Council here in Cleveland. Before we begin, a quick reminder for our live stream and radio audience. If you have a question during the Q&A portion of the forum, you may text it to 330-541-5794, and City Club staff will try to work it into the program. Now, members and friends of the City Club of Cleveland, please join me in welcoming Matthew Fletcher and Cynthia Connolly.
Thank you so much to the America 250 Ohio Commission for your partnership in this series. When we sat down to do the kind of brainstorming on the issues and topics and seeing January's theme for Ohio's First and Originals, we knew exactly where we were going with this, did we not? This is such a great time to talk about our people's contribution to this country and to this state. And Matthew, thank you for braving the weather from Michigan to join us. I don't think it's very often we have two Michigan alum on a stage at once here in Ohio, so we're gonna lean into this moment. So I want to kind of take this, starting kind of before the signing of the Declaration of Independence, before kind of our big, the 250 celebration, and talking more about the role of our nations in the formation of our country, because often it's framed in this way of, we had things taken, which we did, or stolen, which we did, or, as kind of the recipients of the policy and the law that predates the Constitution and our Declaration of Independence. But really, we were active participants in a lot of this law and policy.
Absolutely. And first of all, it's great to be here. I don't get a chance to come to Cleveland very often, so delightful town, wonderful community. And the decades before the Declaration of Independence were really interesting times for indigenous peoples in the Great Lakes, obviously. And, there's some real highlights and interesting points of history that occurred in this region that directly affected why we have the Constitution that we have to this day. So most notably, and I should have mentioned this earlier, the actual structure and theory of the Constitution, which is what we call federalism, where there's a national government and state governments that are sort of all working together, and arguably, at least from some people's perspective, comes from the Haudenosaunee Confederacy, which is basically a model for federalism. You have a confederacy of Iroquois nations or Haudenosaunee nations, and then underneath that you have a group of all the actual specific nations sort of coming together as a confederacy with a national government, so to speak.
It's the Tuscarora, Cayuga, Oneida, Onondaga, Seneca, and I'm missing one, and I'm going to hear from them immediately.
Mohawk, yeah.
Yeah.
It's like the Seven Dwarfs. I can only remember 6 at a time. So, but that sort of influenced the structure of the Constitution. That goes all the way back to Benjamin Franklin's plan of Albany from like 1740. But in 1763, there was a war that actually took place here from a gentleman who is Ottawa from the region called Pontiac. And, he gets a car named after him, but he changed everything. He organized a war against the British colonizers, and at a time when before there was an internet, or telephones, or telegraphs, or anything, he organized an attack on 11 different forts throughout the western Great Lakes, all on the same day. And 8 of those attacks were successful. Pontiac attacked Detroit, which was a mistake, and for him anyway. But what that did was it scared the bejesus out of the British Crown. And the reason for the attack was that there were too many, basically the intervention of settlers and governmental entities, traders within this area was causing problems with indigenous peoples. And so the British Crown reaction to that was called the Proclamation of 1763, in which they prohibited anybody who was a Crown subject from engaging or in any kind of trade or land transactions or anything with indigenous peoples, and routed all of that power into the Crown. That led to a lot of anger amongst American colonists, and that directly led to language in the Declaration of Independence complaining that the, quote, merciless Indian savages were causing problems out on the frontier. Really what that argument was about was the Americans wanted, land speculators particularly, wanted to acquire land from Indian people, and the British, and then later the Americans, refused to let them do it. It created a lot of conflict, but it settled the structure of our Constitution in a national government in a lot of respects. After the Revolution, the United States was broke. It had no real army to speak of. It was in an incredibly vulnerable position. The federal government had no money and had no ability to wrangle in the 13 states. And so what was really the biggest potential economic opportunity for the United States at the inception, at the founding, was what we called the Western lands. So you might see old maps where Virginia, for example, claims in a straight line all of the land directly to the Pacific Ocean. North Carolina did the same thing, Massachusetts. And those are the Western lands. Nobody in the United States even really knew what was there, other than indigenous peoples, and a lot of trees. So the goal was to, whoever had control of the Western lands would basically have control of the United States. And ultimately, because of the way the structure of the Constitution was, if you're going to have a union with 13 different states, and eventually that would become 50, you needed a strong national government. The cost for that was the Western lands had to go to the federal government. And that's why tribes to this day, tribal nations, the 575 federally recognized tribes, deal with the United States in a direct sovereign-to-sovereign, government-to-government relationship. And in the early days, that would have been through treaties.
Yeah, and you mentioned a little bit about Pontiac, and I know the proclamation line that kind of drew this line down the top of the Appalachian Mountains, and within the span of 19 years, sort of marched west into Ohio and what we now know is the Western Reserve and past. Ohio, and particularly, I would say Western New York, Western Pennsylvania, really was kind of this frontier for the Revolution in terms of settlers and colonizers going where they shouldn't be, and really getting some people mad. And I know you had talked about was it Little Turtle and kind of his efforts, and that was a pretty fascinating story if you wanted to share that here.
Yeah, so the first real war post the American Revolution that the United States engaged in is often called the Northwest War or the Little Turtles War, and it really involved the Ohio River Valley, or what the indigenous people around here called Eagle River. And that was the first, basically, frontier. And the theory of the United States Indian Affairs policy at the time was to send in settlers, traders, to engage with the tribal nations. And if things went badly, as they pretty often would do, see the Pontiac's War, that's when you send in the military to take over. And that happened pretty quickly. Starting in 1785 or so, the United States raised an army, again, no money, no real resources, a small army, sent it to Shawnee Territory here in Ohio, and it did not go well for them. And they did this for years. And for about 7 or 8 years, every single army that the United States sent in with an anticipation of forcing compliance from the collected tribal nations, beginning with the Shawnees, but also the Anishinaabe Confederacy, the Three Fires Confederacy, the Miami Confederacy, the Illinois Confederacy, even some Haudenosaunee nations were involved. Huge, giant groups of disparate peoples. Again, year after year, the United States sending an army, always coming back, if at all, completely defeated, until the United States started a plan, basically a guerrilla warfare against guerrilla warriors, and they started kidnapping Indian kids and their moms and grandmas, and holding them in concentration camps. Sending letters, all of this is documented in the American State Papers, 1793, 1794, with a list of all the people they had kidnapped, saying, if you want to see your kids again, it's time to negotiate a peace treaty. And that led to the end of that war in 1795. And the first real significant treaty between the U.S. And Indian tribes, which is the 1795 Treaty of Greenville. And that kind of set the stage for the Northwest Ordinance, all of those policies, the original Trade Intercourse Acts that Congress passed starting in 1790, funneling a lot of power into the federal government, treating Indian tribes as foreign nations. And that's why we have in the Commerce Clause a list. Congress has the power to regulate commerce with the states, that's the Interstate Commerce Clause, with foreign nations, that's foreign nations, and with Indian tribes. So Indian tribes are mentioned in this particular text of the Constitution because that's basically a list of all the sovereignties that do things within the territory and with the United States.
And it's right at the top, Article 1, Section 8, the Commerce Clause, and it says, Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes.
That's right.
And for tribal nations, that's an acknowledgement directly of our sovereignty.
Absolutely. And the British actually are the ones who figured this out in 1763, that the way to deal with these wild bands of indigenous peoples is through a government-to-government relationship. And so that part of that is dealing with so-called commerce with the various different sovereignties that are in play, but also through the treaty power, which is in Article 2. Article 2 is the president's sort of area, the executive branch. So there are upwards of 400 treaties with the United States and various Indian tribes.
And, this is what, a lot of experts refer to as the treaty-making era. And, throughout the period of our history, since the landing of Columbus to today, there's, these eras of tribal federal policy. And they often contradict each other. Like, be one thing is what they're going for, and then completely opposite the next, 50, 100 years. And then it switches again. So treaty-making era is kind of where we're talking about right now. How come there were so many treaties, and then how come they just ended, almost by and large, by the turn of the century?
Yeah, that's a great question. The first treaty between the United States and an Indian tribe was actually a Treaty of Fort Pitt, and that was with the Delaware or Lenape Nation. And the reason for that treaty was, like I said, during the Revolutionary War, was the Americans, their military needed to be able to move through Delaware territory in western Pennsylvania. If they had tried to send an army group through that area without the permission of the Delawares, they would never have seen those soldiers again. So it was a treaty of military alliance. And you don't have treaties of military alliance between the United States and a colony or a state or a territory or even like Microsoft, only with sovereign entities. And that sets the stage going forward for the treaty era. In the first 60, 70 years of the United States, when the United States entered into a treaty with a tribal nation, mostly, again, in the East, that was very much an arm's length, relatively even strength kind of bargaining situation. So the treaty era really set the stage for establishing the federal tribal relationship and sort of excluding state governments from participating in Indian affairs. Which led to a lot of litigation and actually almost started the Civil War in 1832. There was a U.S. Supreme Court case involving the Cherokee Nation of Georgia called Worcester versus Georgia. And at the conclusion of that case, which the tribe effectively won that case, actually the federal government won that case, the Carolina states were sending artillery to Fort Sumter. And you guys have heard Fort Sumter, that's where the Civil War started in 1861. It almost started in 1832. At least in part because of this case.
Yeah, and having that nation-to-nation relationship still is established today, and we're going to talk about that just a little bit later. And I know we want to get to another era of federal policy that we think, collectively, I agree, is one of the most impactful eras of policy that impacted the nation today: removal. Yeah. You want to explain what that means and the outcome of removal?
Well, a large part of these eras of federal Indian law and policy, they wax and wane. Tribal interests sometimes are on the ascendancy, but usually not so much so. So those early decades of federal tribal relationships and treaty relationship, especially in the East, there's an enormous amount of pressure from Americans to push out Indian people. They wanted access to lands and resources that tribal nations had possession of. And part of the reason there is a United States is that the federal government sort of slyly promised to the various states, especially in the South, we will help you remove your Indians if you join the United States. But that didn't happen right away. Not until really Andrew Jackson was elected in 1828, and he was a Southerner, he was an Indian fighter, he was a slave owner. He promised to eradicate all of the Indian presence in this part of the country, basically east of the Mississippi. And that in 1830, the Congress passed the Indian Removal Act, which granted and ordered the president to seek treaties with all the tribal nations east of the Mississippi, in which they would agree to leave and go to places like Oklahoma, what is now Oklahoma, or Iowa, or Kansas, far west of the Mississippi River. And that removal era was a particularly brutal period of time for tribal nations. Most famously, infamously, the Cherokees went through the Trail of Tears in 1838. Hundreds of Cherokee people died on that forced march. In southwest Michigan, northern Indiana, you had the Potawatomi Trail of Death, where hundreds of Potawatomi Indians on their way to Kansas and Iowa were basically walked to death. And the tribe here, Pontiac's Ottawa tribe, here in Ohio, what is Ohio now, was forcibly eventually removed and is now a small remnant of what it once was in the state of Oklahoma. And that removal era set the stage, at least for the East, for basically making it look like there are no tribal nations really left. There are no federally acknowledged tribes in Ohio or Pennsylvania at this point. And that's all a function of this stuff, this sort of history and policy. And you asked earlier, and I didn't answer the question about why treaties stopped being a thing. And in 1871, the House of Representatives and the Senate had a fight over Indian affairs policy. And you might know from how treaties are negotiated and ratified in the United States, the Senate has the right to ratify. The House has no say whatsoever in treaty making. They wanted a say in Indian affairs, and so they just stopped doing treaties. There's no real legal issue there. And we still negotiate, basically, even to this day, we kind of negotiate treaties with the United States every single year. We call them annual funding agreements with the Bureau of Indian Affairs and Indian Health Service. Again, sovereign to sovereign, government to government relationship.
Yeah. When we talk about kind of the progress of federal Indian law today, I want to spend some time here. You know, and actually I should have prepped you a little bit on this. One thing that I thought was absolutely fascinating was one of your pieces on the dark matter of federal Indian law, and kind of, which is a perfect title about how vast this topic is. And I had a friend who was talking with a Supreme Court justice and had openly said that when it comes to federal Indian law, quote, we're just sort of making it up as we go because it's just so complex. Which is not what you want to hear from a Supreme Court justice, but I think it gets to your point of like how untouched and unknown it is. If you wanted to talk a little bit about the dark matter of federal Indian law.
You got to be really grateful to Justice Scalia for speaking his mind. And
I wasn't going to name names, but yeah.
No, it's really helpful to hear that. But yeah, the dark matter idea comes from this. So if you look at the treaties, almost every treaty starts with this notion that we call the duty of protection. It's the tribe agrees in Article 1 of every treaty to come under the protection of the United States. Now that protection is a legal term of art from customary international law. It's the same kind of arrangement that, say, the Vatican has with Italy or with Monaco and France. It's a smaller sovereign nation that comes under the sort of protection, I guess you could say, of a larger nation. And that's the framework that the founders of the United States during the constitutional framing the constitutional period decided to go through, decided to do. So the dark matter is kind of like this. You know, the reason I kind of write that and call it that is because we don't really know what the full scope of the duty of protection is. If you read an Indian treaty, it's like 5-10 pages long. And it doesn't deal with all of the things the United States promises to do in terms of its duty of protection. It doesn't deal with all the things that the tribal nations are reserving for themselves within these treaty negotiations. So to this day, we have, I don't know, in a given year, Congress probably spends $3 to $5 billion on Indian affairs type activities. So it's healthcare, it's housing, law enforcement, public safety, all that stuff. Everything that a government does is at least partially funded by the federal government. And you might wonder, the duty of protection is why Congress does this work. It's always promised to do this work. It doesn't fund at all as much as it possibly should, and it doesn't do the things that it probably should to fulfill its duty of protection. But if you want to know what sort of the value of the duty of protection is, think of, I'll use the state of Michigan because that's my place. The Ottawa tribes in Michigan signed a treaty in 1836 with the United States in which they agreed basically to sell their traditional homelands in exchange for smaller reservations.
Treaty of Washington?
The Treaty of Washington, negotiated by Andrew Jackson's people, Lewis Cass, Henry Schoolcraft, and on the tribal side, Ashwaubenon, Austin Hamlin from Little Traverse. That we came under the protection of the United States, but the transaction was we get small reservations. Maybe Grand Traverse Band is 20,000 acres. I think Little Traverse is 50 or 60,000 acres. We didn't actually get those reservations, by the way, to set that aside. Yeah, but and we got a few $1 million. I think ultimately it ended up being like $15 million. Now, I don't care what you think about the state of Michigan. We sold 1/2 of the Lower Peninsula, or 1/3 of the Lower Peninsula for $15 million. That's not actually what the value of the Lower Peninsula is. If you just count the old growth pine located on the land in which we're located, that's probably, I'm going to pick a number, $1 trillion. the United States will never be able to actually fulfill the duty of protection until it spends down all that money that it owes tribal nations. That's just one treaty in one state.
It's a big mortgage.
It is. But the problem is that nobody really knows what the full scope of it is, so I called it the dark matter, like in physics. There's matter that exists in the universe that scientists can't actually discover, they can't locate it, so it exists, we know it. It's probably black holes, I don't know, but whatever.
Yeah, that's actually a perfect way to describe it. And you're talking about kind of some of the assets that were turned over. It wasn't just land, right? We're talking like timber and water and mining. I know the Upper Peninsula has like one of the largest copper resources in the region. So it's really impossible to calculate the value of what was given. So when we talk about Indian law today, and we use the word Indian law in part because that's just kind of the legal term that is used at this point, also for the census, American Indian. What cases are we seeing come out right now? Like, what are the big ones we should be paying attention to, or just were announced that really helped shape kind of both federal Indian law, the nation, kind of changed the tenor of the policy?
Well, I mean, the era that we're in now kind of started in the 70s. So I was born in 1972. So around that time, my lifetime, the Congress turned to a policy of self-determination. Prior to that era, it was assimilation, it was boarding schools, it was forced adoption of Indian kids, it was stripping tribes of their land and resources.
Termination.
It was terminating the relationship between Congress and the tribes. Hundreds of tribes are terminated. In Michigan, we had administrative termination, which is where the Department of Interior just stopped returning our phone calls illegally for 100 years. It was awful.
Just left us unread.
So with self-determination, though, Congress completely flipped the lid, at least theoretically and policy-oriented, flipped the paradigm completely. And now tribes govern themselves. They're restoring their land base. That's why we have a land back movement. Tribes can acquire land and give it reservation status by putting it into trust with the Department of the Interior. So there's a lot of really interesting things going on in Indian country, and there's a big problem, which is that this United States Supreme Court thinks about Indian affairs and really all of its cases in terms of precedents. And all of its precedents prior to 1970 are ratifying assimilation and dispossession of indigenous resources. So when the tribes are suddenly doing things that they're not supposed to be doing, which is like governing themselves and developing their economies, the Supreme Court lags behind that horribly. But the nice thing is Congress, to the extent that it does attempt to fulfill its duty of protection, does things like pass an Indian Child Welfare Act of 1978, where cases where Indian kids are taken from the reservation and adjudicated in state courts, those cases should be routed back into the tribal court justice systems. So we had a case that's been around since 1978, and it took a few years, actually a few decades, for the Supreme Court to figure out, like, maybe we should determine whether or not this is constitutional. I mean, is Indian child welfare or any child welfare considered, quote, commerce? So that's a constitutional issue that's been kicking around. It didn't come to the forefront until just a couple of years ago, and I think the reason for that, just as an aside, most states didn't comply with the Indian Child Welfare Act, so there was nothing to fight over. But anyway, now there is, and the awesome thing about the Supreme Court is that it's a conservative court. They're textualists. They look at the original public understanding of the Constitution, and they looked at what the Commerce Clause meant in the context of the treaty power and the duty of protection, and they said, yeah, maybe child welfare is not commerce, but it's definitely within the scope of Congress's power and its obligation to tribal nations to do something about child welfare situations. And why we call it ICWA as an acronym. Why was ICWA such a big deal? Why is it still a big deal? Because kids are taken from their homes, and they have been since the very beginning, all the way back to the American Revolution, frankly. Taken from their homes and put into institutions like boarding schools. Some of them, like I said, held hostage way back in the day. And in the middle part of the 20th century, they were taken by state governments and adopted out. So we had urban relocation, where Cleveland was a place, as a location, a target for the Bureau of Indian Affairs to take people from reservations and plop them here, ostensibly in the 50s, to generate economic activity. Didn't work.
Yeah, and the Supreme Court case you're talking about is Brackeen v. Holland,
Yes.
correct? And that was ruled on recently. And another underlying fact of that case is it really reinforced our tribal sovereignty and ability to govern in that way, that we weren't just a racial entity. I think that was one of the underlying complaints of ICWA, is that it treated us racially special. But it really reinforced that sovereign, that political relationship we have with the government. And some may argue that was kind of the underlying reason that they were attacking ICWA, is because if they could attack the political relationship we have with the government, make us just a racial entity, that would just undermine all of federal Indian law.
There's definitely a risk. I mean, you have organizations, entities that are interested in destroying civil rights legislation or limiting those considerably. And that's an issue. But, you look back at the Constitution, there's only one ethnicity mentioned in the Constitution, at least explicitly, and that's Indians. There's the Indian tribes and the Indian Commerce Clause. There's also a provision in the 14th Amendment, weirdly enough, where the equal protection notion or the anti-discrimination notion comes from, referencing something called Indians not taxed. And that's related to citizenship, and it's actually subject to the birthright citizenship cases brought by the current administration. But all that is to say is that Congress actually does have the authority to legislate vis-a-vis Indian tribes in a way that is not affected or should not be affected by normal notions of equal protection or anti-discrimination principles. We're in a government-to-government relationship.
We're going to move to audience Q&A here briefly, but I did want to get one more question in for you, and this is a little heavy one. We actually had Ned Blackhawk here back in September of 2024 as part of our Annis Field Wolf Book Award series, also a National Book Award winner. He kicks off his book, The Rediscovery of America, with this quote. He says, "How can a nation founded on the homelands of dispossessed indigenous peoples be the world's most exemplary democracy?" And it really teed up his whole book. And it's a pretty, if you haven't read it, 10 out of 10 recommend. You can watch it at cityclub.org/archives. What are your thoughts on that? Is there a way that we can reconcile, atone for what was done and for Native Americans and American Indians to be part of this American democracy?
Well, my glib answer is nobody's illegal on stolen land. But my real answer, my substantive answer, is that one of the key principles of American democracy, constitutionally, politically, for at least the last century, and I point to Justice Louis Brandeis for this notion that every state is a laboratory of democracy. So, a century ago, we're coming into the Great Depression, and there's a lot of creativity, a lot of engagement between the states. California might try something in one area, and Arkansas might do something totally different. And it's sort of like a marketplace of ideas where the best ideas rise to the surface, and the worst ones, let's just move on. I don't know that that's really the case with the states anymore. I mean, you have a lot of national control. I mean, if the current administration doesn't want California to do something, it doesn't take that much to stop California from doing anything. And the states are really becoming sort of uniform. But where the real laboratories of democracy are in the 21st century are the 575 federally recognized tribes. And some of them are like Navajo Nation that have a land base the size of Ireland, larger than 10 states, 400,000 citizens. Cherokee Nation, Oklahoma has 400,000 citizens. And some tribes are super tiny. Our tribes are about, small land bases, a few thousand acres, a few thousand tribal members. But we're governing in a way that is incredibly creative. We have to be creative. We don't really have, I guess theorists would say, a monopoly on violence. We can't coerce people into doing our work by sending out soldiers or police officers. And we have to govern by persuasion, which incidentally is basically our foundational political philosophy. And so we're doing a lot of different things with our justice systems, our police forces, healthcare, housing, all the social services that we provide. And a lot of the real innovative ideas that are coming out of modern governance in the 21st century are coming from Indian country. And the real question is, how much of America is going to listen?
A traditional form of justice, too, in governance that we're seeing out of some tribes. All right. We are about to begin our audience Q&A. For those just joining via our live stream and radio audience, I'm Cynthia Connolly, Director of Programming here at the City Club and moderator for today's conversation. We are kicking off our America 250 series, where we will celebrate the semi-quincentennial, or the 250th birthday of our country. This month, we are recognizing Ohio's first and originals, and joining me on stage is Matthew Fletcher, a leading tribal law expert and the Harry Burns Hutchins Collegiate Professor of Law and Professor of American Culture at the University of Michigan. We welcome questions from everyone, City Club members, guests, students, and those joining via our live stream at cityclub.org or live radio broadcast at 89.7 WKSU IdeaStream Public Media. If you'd like to text a question, please text it to 330-541-5794. Again, that's 330-541-5794, and City Club staff will try to work it into the program. We have our first question.
Coming off I have a bunch of questions for you, but I'm going to do the one. And directly talking about these, the black holes that you're talking about, these, dark areas of law, and talking more specifically about movements with land back and re-navigating our, Native people's legal existences. What do you think of the kind of recent developments in specific for land back movements of the doctrine of discovery's removal? So for those in the room who don't know, doctrine of discovery was initially a concept from the 1400s, from the papacy, saying that Christian monarchs and their representatives, if they came across land that was not ruled over or administered by Christians, they could seize it. And that led to Portuguese and Spanish colonization, and the United States used it, Johnson v. McIntosh, and most recently City of Sherrill versus Oneida Nation in 2005. So the United States has actively used the doctrine of discovery as their foundation for why Native people are never allowed our land back. However, the papacy in March 2023 rescinded the doctrine of discovery entirely. So what does that say for Native people now that that bedrock that the U.S. has been using is no longer supported by, the international community that initially framed its existence?
Johnson v. McIntosh, that was 1800s?
1823?
3 or something like that?
1823, yeah.
Sorry.
Well, a couple of things. You're asking a cynical lawyer about a doctrine of discovery. There's no basis in law for the doctrine of discovery, and that's absolutely right. And I think actually there's a Supreme Court justice who wrote exactly that just a few months ago. Neil Gorsuch wrote something in a case that's not terribly relevant. But the thing about the doctrine of discovery is that, yeah, it's gone. I mean, it's been a dead letter for so long that it doesn't really matter anymore. It's sitting, sort of on the books of the United States Reporter. It's kind of like a doggy doo-doo on the lawn, but it's not going to hurt anybody. That said, the real response to any kind of pushback to tribal governance, tribal sovereignty, is really more governance and more sovereignty. And I really have to emphasize, tribes are doing really amazing things. If you are forced to govern with a limited amount of power, limited resources, limited lands, you're going to come up with unbelievably impressive things. We mentioned the Indian child welfare case, how these cases have to be routed from state courts into tribal courts. So in 1978, there weren't very many tribal courts in the United States. So you know what we did? We made up tribal courts. We started child welfare proceedings. We developed our tribal welfare codes in light of our customs and traditions. So, in Michigan, we would, most of the child welfare codes reference a principle in the language called Minoba Bodzewin, which means living your life in a good way. And that's the core principle for most of our governance, even if we don't say it out loud. And that's where all the really interesting, exciting things are coming from. So, yeah, you brought up City of Sherrill. That is an ugly, ugly case, right? It's a case where a tribe in New York tried to assert its sovereignty, and the Supreme Court said, when you bring a lawsuit, it's really disruptive to your neighbors, the non-Indian communities that are around you, and so we don't think you should be able to do that, so your case has gone away. If that case actually had more meaning beyond that, it would mean that all of Indian law goes away. And the person who wrote it was Ruth Bader Ginsburg, and right before she died, to her credit, she said that was one of her biggest regrets, was writing that opinion. It is virulently racist in every conceivable way. Luckily, the court hasn't done much with Cheryl at that point, so we'll leave it off to the side, one of those doggy doo-doo things. And it's all true. That said, tribes get around a lot of this by just doing a better job. My friend at UCLA, Angela Riley, who's Citizen Potawatomi Nation, wrote a paper called Good Native Governance, and that's the answer to everything. Kind of like the response to restrictions of free speech is more speech, the same thing is true with governance.
I guess there's a lot of confusion on Indian lands if non-members are subject to tribal law. And you wrote an article where you compared it to U.S. immigration policy. If you immigrate here, you are bound by tribal law. Was that what you were trying to say in a brief sentence?
Sure. Well, you're asking it's hard enough to ask a lawyer for a specific question. Now you're asking a law professor for a specific answer. Good luck to you. Generally speaking, yes. We lost a lot of our land. It's been taken from us, and a lot of Indian reservations are, 60, 70% of the people who live on them are not tribal citizens. Most of the land is not owned by the tribe. But the reservation boundaries remain extant. They're real things. And that matters a great deal, especially for criminal jurisdiction. And tribes are sort of governing with, almost in competition with state and county governments, and sometimes even with the federal government, ostensibly our protector. And that creates a lot of litigation, a lot of conflict. There are a lot of tribal nations, almost all tribal nations have membership criteria. In order to become a citizen or a member of the tribe, you probably have to have some ancestry with a tribal nation. And that's kind of an icky thing in the United States, at least since the 14th Amendment, birthright citizenship. The reason we have that, of course, is because our colonizer demanded that we have blood quantum rules, so set that aside for a moment. My position on tribal nations is if they want to govern people, they need to figure out a way to reach a consent of the governed type scenario that we have here in the United States, at least in theory. That might mean tribal nations have a naturalization process where people come live on the reservation, they can become sort of a citizen in some respects without having to worry about the blood quantum thing, and they could participate in tribal governments to some extent. But actually, since I wrote that, and this is almost 20 years now, the courts, especially out west, have been pretty receptive to tribes asserting jurisdiction, especially jurisdiction for land use type things, pollution, dumping. And the reason is that tribes are actually governing very, very well. And so that to me, again, is another response, that tribes have different avenues in order to fully govern their reservations. And the real thing is, and this is what Indian lawyers do on the ground, is we reach cooperative agreements with our neighbors. We don't fight with them nearly as much as than we used to. And that, to me, is a huge step forward.
Thank you, Professor, for coming to Cleveland from Michigan, and I'm sorry about your football team. But
I'm sorry about yours.
Touche. My question is about the very concept of property ownership, and in particular during the treaty era. I think it's fair, I presume that the white settlers certainly believed in the concept of individual property ownership during the treaty era. Was that shared by Native Americans who were negotiating on the other side? Did they have a concept generally or specifically of individual ownership of property?
Absolutely. And it obviously was different. So, think of the tribes in the Great Lakes lived in a sort of a seasonal way. We didn't stay in the same place every single time. Think of the Grand Traverse Bay. My ancestors, our ancestors in that area would have spent the summers on the beach. That's where we should be spending our summers anyway. That's where all the agricultural activities, a lot of the fishing, generating, stuff that you need to live through the winter. And in the wintertime, we would move inland to where the tree cover is, and we would break up into smaller groups. That's where a lot of the teachings occurred, and you kind of hunkered down for the winter. Spring would go into sugar bush territory, which is where the swamps are, and generate our sugar and syrup, things that we would need for the rest of the year. All of these things were generated assets for trading economic activity. At the same time, indigenous people, I think this is true for basically every tribal nation, and at least in North America, had a much broader, expansive understanding of what property meant. And we would have acknowledged property rights, not that we had rights over these entities or places, but property rights that existed in the land itself, the trees, the rocks, all sorts of the fish, all the animals were themselves independent entities that possessed their own version of property rights. Probably another way of putting it is if you think of where humans sit. I grew up in a pretty conservative Christian household. I learned a lot about, in college, in high school, I learned a lot about John Locke. You can't own land unless you improve it, and that means cutting down the trees and putting down rows of corn or something like that. That assumes that humans are here to exercise dominion over the world around us, that we are the most important things around us. It's right there in the Bible. For a lot of indigenous people, definitely Anishinaabe people in this area, it's the exact opposite. Humans are critically important, but we were created last, so to speak, because we were actually not that important. As a friend of mine, Eric Hemingway, likes to say, trees don't need us at all. We need trees desperately. And I think that kind of philosophy shifts around understandings of property that is, that sort of makes it look like, to outsiders that we didn't have property. We didn't believe in property rights. And the exact opposite is true. It's just a different idea of property.
Great.
So since you're on tribal courts, my question is specific to that. How have tribal courts been able to imbue white law with their interpretations or their view of Native American culture, and how does that impact sovereignty and the ability to be more expressive and utilizing the law to promote Native sovereignty?
So glad you asked that. I love my work with tribal justice systems. I'm an appellate judge, so I don't have to be on the reservation every single day. I get the privilege of just sitting around reading and listening to people talk. There are probably about 400 tribal justice systems, tribal court systems out of the tribes that have them. And every tribe in Michigan has a robust court system. Some of the things we do, at least things that I do, not everybody goes down this road, but some of the tribes have been going down this road of trying to interpret things like the Due Process Clause, right? The U.S. Constitution has it in 2 different places. Most state constitutions have a version of what Due Process Clause means. You learn about it in constitutional law in your first year in law school. To me, due process means this: the bare minimum the government has to do before they take your life, liberty, and property. Bare minimum. That's not exactly what the Due Process Clause says. It just means that's how it's been interpreted by the U.S. Supreme Court and by policymakers. Tribes don't have to do it that way. We can look at due process through the lens of something like Minoba-Madswin, or Navajo Nation's justice system would refer to the principle of Ke, which I'm pronouncing horribly, even though it's a simple thing to pronounce. These are principles that allow for individual people to have sort of some way to push back on the government. Another good example is a principle that is not even in the U.S. Constitution, that I really was angry that the Hamilton play did not mention anything about Federalist Paper 81, which is where the notion of sovereign immunity comes from. You cannot sue your government unless your government allows you to sue it. And even if the government passes a law saying you can sue us for this thing, the courts will interpret that language as narrowly as possible to the benefit of the government. And that doesn't come from the U.S. Constitution. There's nothing in the Constitution that references, say, for example, federal sovereign immunity. And so why do we do this? Tribal nations don't have, they have sovereign immunity too, and they pass laws waiving immunity. We don't have to construe them all that narrowly. We can, if you pass a law saying you should sue us, we could actually construe that very broadly to allow for a lot more lawsuits. And if you follow anything about police, you will see in the event that something really bad happens with a police officer and you try to sue that person, that officer, you're going to lose. That doesn't necessarily have to be the case with tribal communities. So those are just examples.
You spoke during your remarks about the Bureau of Indian Affairs and the annual funding agreements, some of the things that that funding supports for tribal communities, and the fact that there's never enough. But could you talk about how that funding works practically? Are there negotiations every year? Does the funding change every year? Does it change every 4 years with new administrations? And what's the circumstance today under this administration?
Well, these annual funding agreements come from the 1970s statutes that establish self-determination as the founding, sort of the paradigm now. Every year, Congress establishes a number. And I mentioned like $3 to $5 billion. I just made that up, but it's something like that. And then out of that number comes all of the money that's going to go through self-determination contracts to tribal nations. Every tribe gets a piece of that. And within that piece are a bunch of basically line items. Every kind of governmental service that that tribe provides or historically has provided gets some aspect of that. And the tribes and the Bureau of Indian Affairs or Indian Health Service and a couple other federal agencies can negotiate which amount of money that is available goes into each sort of slot. And then that money goes, as the BIA, the Bureau of Indian Affairs, is a pass-through entity. And if the tribe doesn't want to do that, actually the BIA will be on the hook and have to do the governance on the reservation. Most tribes don't like that, but it is what it is. But that's never enough. And so what tribes do is and Congress has acknowledged this in lots of different statutes over the past 100 years, they have to have business entities to generate governmental revenue to supplement what it is that Congress does pay for. So my tribe, we had to figure this out 20 years ago in a piece of litigation. 85% of our governmental budget comes from our casinos. 15% comes from the federal government. So that gives you and we don't feel like we're fully funding our government even with the gaming revenue, but that gives you a sense of how much Congress is actually paying for. And I think that percentage is pretty consistent across the country. But if you're in South Dakota or in Alaska, you don't have much gaming revenue. You're just stuck with what Congress provides you. That puts those tribes in incredibly disparate straits, and that's kind of how these things work right now.
I am Kathy. I'm one of the commissioners for America 250 Ohio. Thank you, Ben, for being here. One of my position on the commission is one of the co-chairs of the Undertold Stories Committee. And what we are trying to do is seek to amplify the stories of people whose stories have been not in the history books. So my question is this. Given the fact that Native Americans are not a monolith, obviously, as are no other groups, in what ways do you personally think that is the best way to have a story be told for people who know just enough but want to know more and really should know more about how Native Americans helped build our country and, of course, Ohio, too?
Yeah, that's a great question. I'm privileged to have friendships with people who are creative artists to this day. So, for example, Angeline Boley is a Sault Ste. Marie tribe of Chippewa Indian citizen who's written a series of young adult novels in the last few years. Most recent one is
Daughter.
Firekeeper's Daughter was the first. The most recent one is called Sisters in the Wind, and it's a narrative about an Indian child welfare case, basically, or a series of cases. And it gives you a sense of how tribes operate in the modern era, the contemporary era, and given with this long, lengthy history of trauma and dispossession that infuses all of us, whether we like it or not. I mean, I don't know a single Native person I've ever met who does not know somebody in their family who has been removed by the state, even in the 21st century. So those sort of stories, I think, are a really good start. And they're fictional. So there's Reservation Dogs on television, Rutherford Falls. Those shows are written largely, if not exclusively, by Native people. So that's where I think you should start. And you mentioned Ned Blockhock's work. So we're starting to get historians who are looking at the old histories from an indigenous perspective. And as a lawyer, I can tell you that the justices on the Supreme Court, they didn't take any Native Studies classes. They did not take federal Indian law. So they learn from reading, just like most people do. And what they read tends to be the worst of the worst kinds of analyses. And so it's nice that I think if you focus on what indigenous people are doing now, writing fiction, writing TV shows, and also the histories and sort of stories about how tribal nations are governing, I can tell you right now, those are not the most scintillating stories, but that's where you go to learn what's going on. And you can see how tribes have been adapting, sometimes for centuries within this environment.
Rebecca Nagel's podcast, This Land, it's 2 seasons, is probably one of the most well-done podcasts I've listened to that covers just not only tribal law, but also kind of culture and everything. It was really well done. All right, well, we are at time. Thank you so much, Matthew Fletcher, for joining us at the City Club. Miigwech. For more information about the year-long celebration across the state of Ohio, please visit america250-ohio.org. Again, that's america250-ohio.org, and also cityclub.org for our upcoming programming for the series. And forums like this one are made possible thanks to generous support from individuals like you. You can learn more about how to become a guardian of free speech at cityclub.org. Today's forum is presented in partnership with the America 250 Ohio Commission, with support from Bank of America, Rock Family of Companies, and Cleveland Cliffs. The City Club would like to welcome students joining us from MC Squared STEM High School. So sorry, no snow day for you guys. We would also like to welcome guests at the tables hosted by the America 250 Ohio Commission, Bank of America, Cleveland Cliffs, and the Lake Erie Native American Council, and Rock Family of Companies. Thank you all for being here today. I'm Cynthia Connolly. This forum is now adjourned.
For information on upcoming speakers or for podcasts of the City Club, go to cityclub.org.
The ideas expressed in City Club forums are those of the speakers and not of the City Club of Cleveland, IdeaStream Public Media, or their sponsors. Production and distribution of City Club forums on IdeaStream Public Media are made possible by PNC and the United Black Fund of Greater Cleveland, Incorporated.